The clock is ticking. In 3 minutes, your $1 million claim could vanish forever. Drawing from hundreds of construction and liability cases, I'm revealing the hidden deadlines that blindside business owners. Don't file another claim until you hear this. Today, we're tackling an essential topic in Florida law, one that can make or break a legal case. If you're a contractor, manufacturer, business owner, or professional dealing with potential claims, understanding time limits in the legal system is crucial. We're talking about the statute of repose and the statute of limitations, two distinct legal deadlines that impact construction defects, product liability, and professional liability claims. If you've ever wondered when a claim officially expires, what triggers these deadlines, or how they might be extended, this discussion will clear it up. Now here's why this matters. Missing a deadline can mean losing your legal rights entirely, and that's a tough pill to swallow when you've been wronged or accused. So let's break it down in plain terms and get to the bottom of it. So what are we talking about? The basics of time limits in law. Every claim has a shelf life. You don't have forever to sue someone or defend yourself. The law sets strict deadlines, and that's where these two concepts come in. The statute of limitations is a familiar term. It sets a time limit on filing a lawsuit from the moment you discover or should have discovered the issue. It's about fairness. The law wants people to act on claims while evidence is still fresh. But then we have the statute of repose, which is stricter. Unlike the statute of limitations, the statute of repose sets an absolute deadline no matter when you discover the problem. It doesn't matter if the defect or injury came to light years later. The clock runs out and the claim is gone forever. So what are the triggering events? What starts the clock? For statute of limitations, the clock typically starts ticking when the injury or defect is discovered or reasonably should have been discovered. So if a construction defect appears in a building 10 years after completion, the owner still has a shot at filing a claim if they act quickly after noticing the issue. For statutes of repose, it's different. The triggering event isn't discovery, it's the fixed event set in stone. In Florida construction law, that might be the completion of a project. For product liability, it could be the sale of the product. No matter when a defect appears, if the repose period has run its course, the case is over before it even starts. For construction defects, Florida has a strong legal framework for handling these claims. If you're in the construction industry, this is one area where the difference between repose and limitations really matter. The statute of limitations for construction defects in Florida is typically 4 years from when the issue is discovered, but the statute of repose is 10 years from the date of project completion. So let's say a homeowner notices several structural cracks in year 8. They can still file a claim because the 10-year repose period hasn't expired. But if they wait until year 11, too late, the statute of repose wipes out that claim entirely. That's why contractors and property owners alike must stay on top of potential defects and act quickly. Product manufacturers and sellers also need to be aware of these deadlines. In Florida, the statute of limitations for product liability cases is 4 years from the injury or when damage was discovered, but the statute of repose is 12 years from the date the product was first delivered. This means even if a defect is found much later, there's a hard cutoff at 12 years. For example, imagine a company sells industrial equipment and a defect doesn't cause injury until year 13. Even though the victim just found out about the issue, the claim is completely barred by the statute of repose. This is especially important for manufacturers and sellers of long-lasting products like construction materials, medical devices, or heavy machinery. If you're in that business, understanding these legal deadlines can save you from unexpected liability years down the road. Regarding professional liability claims, when do professional liability claims expire? Professionals, especially architects, engineers, and accountants, also have legal deadlines to worry about. The statute of limitations on professional malpractice is generally 2 years from discovery. The statute of repose, however, is 4 years from the date of the alleged malpractice. That means even if malpractice isn't discovered right away, there's a firm 4-year deadline in most cases. For example, if an architect designs a faulty structure and the defect isn't discovered until year 5, the client is out of luck. The statute of repose has wiped out their legal rights. Now you might be wondering, are there any exceptions? Can these deadlines be extended? Yes, in some cases, legal doctrines like tolling can pause the clock. For instance, Fraud can toll the statute of limitations. If a builder intentionally hides a defect, the time limit might not start until the fraud is uncovered. But here's the key difference. Statute of repose are rarely extended. Courts enforce them strictly because they are meant to give finality to legal claims. Florida courts have dealt with many claims clarifying these statutes. One key ruling reinforced that statute of repose create an ironclad deadline that cannot be extended even in cases of hidden defects. In construction and product liability law, courts consistently uphold these hard deadlines, making it critical for businesses and professionals to act within them. So how do you protect yourself? First, document everything. If you're in construction or product manufacturing, keeping detailed records of completion dates, sales, and contracts will help you track time limits. Second, act quickly. If you discover an issue or suspect a claim against you, consult an attorney immediately. Time is not on your side. Finally, if you're in business, work with legal counsel to ensure you understand how these deadlines affect your contracts, warranties, and risk management strategies. Understanding the difference between the statute of repose and the statute of limitations isn't just a legal technicality, it's a key part of protecting your business, your property, and your rights. The bottom line, if you wait too long, your legal options may vanish. And when the statute of repose runs out, there's no second chance. So whether you're a contractor, manufacturer, or professional, knowing these deadlines can keep you compliant and prevent costly legal battles down the road. Thanks for tuning in, and if you have any questions about this or other legal topics, drop them in the comments below. Don't forget to like, subscribe, and share this video if you found it helpful. Until next time, stay informed and stay protected.